And we are live. Thank
Hey,
you, folks, for joining my friend Andrew Weissman and I as we unpack a new Judge Cannon ruling that, even before it was issued, there was a pending appeal for her last ruling on the release of Volume 2 of the Jack Smith Report. This is her ruling permanently blocking the release unless a appellate court finds otherwise. We're going to dig into the ruling, what it says, talk about some of the actual history behind some of her assertions. And I can't think of a better person to unpack that than my friend Andrew Weissman. Andrew, great seeing you again.
really nice seeing you. We're twinsies. Although I'm wearing my UCL um, sweatshirt, which is in UCL is University College London, where I was this past fall. But yeah, and the other thing we're going to cover, by the way, with respect to Judge Cannon is like what's next? Like, can the 11th Circuit, the Court of Appeals over her, like what are their options in terms of how to deal with this? But this is, I'm sure most people listening to this are like, Judge Cannon, like isn't like it's like Jaws, which is just when you thought it was safe to go back in the water, people have to be like thinking, what kind of trouble is she doing? And I can give you my big top line of this, which is not going to seem very legal, which is just, I at some point I really just lost complete and total respect for her. And I'd been trying after, if you remember, she had been reversed twice by the 11th Circuit.
Right.
And
Before we even started, before the case started in the investigative stage.
exactly, and she was reversed twice, and even then, I was trying to give her some benefit of the doubt when the actual case was brought, and then through a confluence of her decisions, I was like, "And I'm done." I couldn't think of a good faith explanation, and this is I mean, I don't know how many nails in the coffin you need to, because it's like, I mean I mean, that's such a bad analogy because it is shut, closed, nailed, stapled, glued, insured. I mean, like, I am it is so appalling, and the only thing that I will say to people is that don't jump to the conclusion that if you're, appointed by Donald Trump, it means you're gonna be like Judge Cannon and be all in. We just came off the tariff decision. Amy Coney Barrett and Neil Gorsuch, who were appointed by Donald Trump, they ruled against the government's position there and were then vilified the same day by the president. Numerous district court judges who were appointed by Donald Trump in the first term have ruled against him, meaning that they're judges who take their oath of office seriously and act out of principle. And I'm afraid to say, in my opinion, Judge Cannon is not one of them. By the way, my dog is busy. Wants more attention. I was teaching all day, and so my dog is like, "What's going on?" Like, so
I was thinking maybe the dog has strong opinions about Judge Cannon because he's a very good boy. I can see right now.
yeah,
Oh, so sweet, so sweet. So my fellow gray sweater twin, let's start on one of the points of the
yep.
decision that page 13, because this jumped out at me. It seems so egregious, and I think as a former Mueller prosecutor, you might have some views on this, but I'm going to bring a
Wait,
kind
wait,
of
Adam, can I just tell you, it's so
yes.
funny that you're saying that because, I've got my phone up and we're doing this on our iPhones but on my computer, guess what page I have up? Page 13.
13. Well, because it's the most egregious. I'm going to read this now for viewers.
Yeah.
We have more than 1,000 of you joining us right now. And this to me just seems so egregious. While it is true that former special counsels have released final reports at the conclusion of their work, it appears they have done so either after electing not to bring charges at all or after adjudications of guilt by plea or trial. The court strains to find a situation in which a former special counsel has released a report after initially criminal charges that did not result in a finding of guilt, at least not in a situation like this one where the defendants contested the charges from the outset and still proclaimed their innocence. Let's set Mueller aside for a second. The John Durham report, two of the three defendants in that case were acquitted, and John Durham released a report at the end of his investigation, laying out the allegations against them that were rejected. What's your
Um,
reaction to that passage?
um, so that is, let's just go through the facts and it will show people why I am of the opinion that it's a bias that is absolute, that it's untethered to the facts and law. So John Durham, first, let's just start with this. Every special counsel that we have seen in the current, whether it's a special counsel, independent counsel, they've all issued reports and they're all public.
Right.
All,
Such an
every single one. So then she's trying to parse out, let me see, what she's really saying is, I've looked at all of the prior cases and I have not found one, Adam, where you have released a report where it had to do with Donald Trump now. And so there's no precedent for what you're doing because there's not a single one which it involves Donald Trump. Oh, wait, there was one involving Donald Trump that involved Mueller. So no, Donald Trump now. So like these are distinctions without a difference. It's what a friend of mine used to call the web foot defense, which is they're charged with murder and the person wants to get up and tell the jury, but judge, I have a web foot. It's like, and these are not factual differences that mean anything. So John Durham is a really good example. The Mueller report is a really good example. We didn't elect to not charge him. We could not charge Donald Trump because it was DOJ policy that you could not charge a sitting president. That may, in fact, be the law as well, but it's certainly DOJ's view of the law. And so because Director Mueller, who was then special counsel Mueller, was part of the Department of Justice, he had to follow that rule. He would have been fired if he didn't. You know who released the report that we issued? Bill Barr.
Mhm.
Bill Barr determined to do it. Merrick Garland issued a report involving um, the sitting president, Joe Biden. Um, and I mean, these things go on and on. And so every single, it is true that issuing a report is in tension with the normal rules in criminal cases, the sort of what I call put up or shut up, meaning normally you do an investigation and if no one's charged, no one's supposed to know about it, absent the defendant or the putative defendant saying something, saying I'm under investigation, et cetera. That's not what happens in a special counsel situation. In a special counsel situation, under current rules, um, there's a report that's issued by the special counsel to the attorney general, and then the attorney general decides whether to release it or not. But as I have said, every attorney general has determined to release every single special counsel report. And so, can I just focus on another piece
Absolutely.
that I think is going to get her reversed, which is she basically comes out and says that Jack Smith violated or all but violated her orders. An incredibly dangerous thing to say with this administration because they
Mhm.
are probably looking this going, oh, can I charge him
Right.
with violating that? She knows what she's doing. Um, and what's her basis for saying that? She's saying, one, I determined that he was invalidly appointed. What she fails to note is every single judge who has had that issue has found it the opposite. And she is the only judge who has said that. So she gave a ruling for Donald Trump that isn't highly questionable. Two, while she points out that it was on appeal, she makes it sound like Jack Smith appealed it, but then decided, I'm just going to drop it. No, he dropped it because Donald Trump was elected and the case couldn't go forward because you can't charge a sitting president. So it's not that he dropped it because he thought that she was right. And then third, and this is the kicker, she is saying that it's outrageous that Jack Smith, in spite of what she ruled, continued to compile a report. That report is an internal document to the executive branch. It is a report under the rules by Jack Smith to the Attorney General. Period. The end. I'm sorry, does she have authority over internal communications within the executive branch? I think not. You know who ruled against that issue? The Supreme Court of the United States in the Trump immunity decision. So it's not like she's just saying, oh, he was preparing this because he was going to make it public. He wasn't going to make it public. That's not the way it works. The special counsel is internal to the executive branch. They can have all the communications they want, and that report goes to the Attorney General, and then the Attorney General decides what to do with it. Um, it is so outrageous that she did this. And the other thing that's missing, sorry to go on a tirade,
No, no,
is this motion, because most people are going like, how is this coming up now? I thought this was something where um, people, news organizations, the Knight Institute wanted this released. And it wasn't that like over a year ago? And the answer to that question is yes, it was. What she leaves out there is the 11th Circuit had to scold her to say, you cannot sit on those motions asking for a release because she just wasn't ruling. She was like, I'm going to avoid this and I'm not going to ever get appealed and I'm going to just put this off because I'm just not going to issue a ruling. And what happened was the 11th Circuit had to say, if you need to issue a ruling by this date, meaning, or else they can issue what's called a mandamus that orders her to do it. And so not in the opinion at all. Like no recognition. It's like so again, if you're a jurist and you're trying to be impartial, um, you like when you're a prosecutor, the good and the bad needs to be presented. You need to be forthright. Um, just to be clear, we pay her salary. She is a public official. It is you do not present one side of a story. And so that's like a yet another thing that is deeply, deeply problematic with her decision. Anyway, I've gone on and on, Adam. So you're probably just like, you need to
No, you've been providing excellent context and going off what you were saying, we also, as taxpayers, pay for special counsel investigations, which is why there have always been public reports. That's been that's been part of the reasoning for the legal requirements to write a report and to, as you put it, release every single one until this moment where we have the volume 2 of Jack Smith's report, a big question mark after it with this appeal. So kind of moving on to,
can I just say
yeah,
again,
absolutely.
big picture? What are they afraid of?
Right.
To me, it reminds me of, I mean, do we have to go through a whole Epstein thing, which we're still going through? What are you afraid of?
Right.
Like, if there's, this is one where that is the point of the special counsel. That is to give the public, after an investigation, what has been found. That doesn't mean that the public has to agree with everything in the special counsel report. They can make their own decision. They can decide it's biased. They can decide facts are left out. But it's more data. This would be the first one that has not been released. And to me, it's like the Epstein files. You sit there and say everything needs to be made public. Well, it's not. Right now, the Trump administration is in violation of the law that required everything to be revealed. It required them not to assert the privileges that they are asserting. And if there is, and if you, Adam, were innocent, the very first thing that you would say is, I want every single thing about me and every photo turned over immediately because
Mm.
I want to make sure I can tell the public every single thing about me has been released. Why is that not happening? There's no innocent explanation. Here, President has said over and over again that he has done nothing wrong, that he is innocent of the charges about retaining national defense information illegally, and he was charged with 2 types of obstruction of justice. So let him make the argument based on actual facts, and not just adjectives and bumper stickers.
Mm.
Again, it's like, why are you keeping the facts from the public when it has never happened before? And now this gives cover to say, look, this wonderful judge says it would be improper. This probably is a good way to tee up what can happen next.
Right. Let's move on to that. But I do want to say one, your Epstein analogy is apt, and it happens on the heels of another major development, another arrest in the UK of the former British ambassador to the United States, Peter Mendelsohn, the second big shoe to drop in the wake of the release of the Epstein files. I just want to put a pin on one other thing that you were saying before we pivot to the 11th Circuit and what's
Yeah.
potentially ahead there. Uh, Judge Cannon, her theory of the case, I'm looking at her language right now, the presumption of innocence held sacrosanct in our constitutional order. As you noted, the Mueller report, we saw the airing of all of the evidence that was compiled in that investigation. The Starr report, we saw all the airing of the evidence compiled in that investigation. The
The
Hur
Biden, her report on the sitting president, the
right,
sitting president. So there's precedent for it to come out with respect to a sitting president.
right,
And remember, Robert Hur was of somebody who was who worked in the administration, the Trump administration, and was tasked by the Garland Justice Department to do this report of a president in an opposing party. So that can't be the distinction. By the way, in the Mueller investigation, the report dealt with people who had been charged but not convicted. It dealt with people who had been not yet charged. It dealt with people who had been um, uh, uh, charged and convicted. In other words, you can look at that, and there's like a whole panoply. The
right,
the one where we were most sensitive was the was where it was naming people and giving information about people who were charged, who were awaiting trial.
right.
And so, like, Roger Stone would be an example of that, if my memory serves, because then you want to make sure that a jury is not tainted by by that report, because because the court was like, I need to pick a fair jury, and I don't want this information going out. That is legit. We're not in that situation.
Mm.
We're in the routine situation that happens all the time. And it's funny because I was looking at that page 13, and I just don't see any discussion of all of those other special counsels and what happened. I mean, it basically is, there's no other case involving where the name of the person is Donald Trump in his second term, because
Right.
she couldn't even say Donald Trump in his first term.
Right. And even some of the things that she affirmatively states just seems incorrect. That did not result in a finding of guilt. And that's just plain old the Durham report. Let's talk about the Knight First Amendment Institute. They were the
Yeah.
ones who brought that case that you pointed. led to that extraordinary, slap on the hand to Aileen Cannon saying, you need to hurry up. It came on an application on mandamus. So it's extraordinary that they acted on that, telling her to speed up her timeline. That appeal remains pending. I just spoke to a senior attorney from the Knight Institute, and he had mentioned that when they were denied intervention into the case, they appealed. That is pending for oral arguments coming up this summer. How do you expect that case will go ahead?
So this is where procedurally it is complicated. And people listening to this are probably going to be like, and it is somewhat why lawyers can have a bad reputation because there is a lot of procedural niceties to this. In the case before Judge Cannon, there are two parties who are in violent agreement. You have the um, the putative defendants, so Donald Trump, Walt Nauta, for instance, um, and you have the government. But of course, the Department of Justice is now um, to say in bed with is an understatement because there's now no separation because you have the president just directing who gets charged and who doesn't get charged.
And I don't mean to interrupt, but they made that eminently clear recently by putting Donald Trump's face on a banner in front of Main Justice. Continue, Andrew.
Yeah,
I didn't
and
interrupt.
and just directly, and we get to see directly saying charge James Comey. And by the way, if my own hand selected U.S. attorney won't do it, I'm firing that person and I'm putting in somebody else, even if it's later found that Lindsay Halligan, who I just put in there to charge James Comey, that was illegal. All of that was found by the courts. Um, so, um, so you have both parties doing this essentially on consent. And so Judge Cannon kept on saying, this is unopposed. This is unopposed. Well, it's unopposed because the American Oversight and two institutions, American Oversight and the Knight First Amendment Institute, which is up at Columbia, and it, by the way, is a wonderful First Amendment institution with serious, lovely, thoughtful people. I don't agree with everything they do, but I have dealt with them repeatedly. It is always an absolute pleasure because they're just so smart, and you engage with them on a where everything's thoughtful. They're just terrific. So they asked to see this volume two. They filed a motion, and they also filed, as you mentioned, Adam, to intervene. In other words, to be allowed into the case. And one of the reasons they want to be allowed into the case is because there's nobody advocating for the First Amendment, right? The right of the public to see it, because you have the defendants in the Department of Justice, just on one team. And so very often a reputable judge will actually, without even being asked, will appoint what's called a friend of the court, an amicus brief. That literally means amicus is like friend. So it's like called an amicus to come in to represent an opposing view. And by the way, I have been an amicus where a wonderful judge in the Southern District of New York, asked me to come in. We did. He thought it was important to have a different view. It didn't mean he was going to rule for us. In fact, he ruled against the position we advocated, but he wanted to make sure that the position was heard as forcefully as possible. And so he had the benefit of that thinking. Obviously, I maybe didn't do a very good job, but meaning that is what you do as a fair-minded jurist. What did Judge Cannon do? She said, you cannot intervene. You
Right.
cannot be part of this. Why is that interesting? Because in the actual criminal case, there is no party to that case to appeal it.
Right.
Now, who's going to appeal it? The government's not going to appeal. The government won. who's going to appeal it on the defense side? Not the defendant, because the defendant won. So procedurally, um, what's the way forward? Because people have to be going, oh my God, this can't be how justice works. And it may not be, because, as you said, what is up on appeal is the technical issue that that the Knight Institute and American Oversight brought, which is we should have been allowed to intervene, and we should, and our, as well as our claim to have access should have been allowed. Now, that's not quite a direct appeal. And so the 11th Circuit can be quite a stickler for sort of what technically is on appeal and what technically isn't. They have the ability, though, to convert it. They have the ability to appoint an amicus. They have an ability to say, we're going to overrule Judge Cannon's decision about intervention, and then we'll hear it. And they have various options, but I suspect we're going to see an application from the Knight Institute, either at the district court level or at the Court of Appeals, also to speed things up so that we're not waiting for argument in the summer,
Right.
given what's going on. And this is like the playbook this is Judge Cannon's playbook of delaying the case until the election, so that it's like no one goes to trial, no one sees the light of day, even on a case that's relatively simple, because I'm just going to keep kicking the can down the road because it's in because it's in Donald Trump's interest. So it is a very technical thing about how this gets to the 11th Circuit. Once it gets to the 11th Circuit, like once procedurally can work through this issue about how to get it in front of them when you have two collusive parties, um, I think it's going to get reversed. You have to remember to start at the beginning where we started, Adam.
Mm.
When this was in the investigative phase, Judge Cannon was reversed not once, but twice in scathing decisions. I actually was just teaching one of them. Scathing.
Right.
Um,
One of
I
them
remember at the
called
time
her
thinking,
actions radical. Continue.
yeah, I mean, and by the way, the 11th Circuit is a conservative circuit. I mean,
Right.
so like this is not like there's no politics here. This is 11th Circuit judges going, that is not what we signed up for. We
Right.
have conservative values. Those are embedded in the law. I mean, this is very much a theme that Mary and I in our podcast, just a quick plug,
Sure.
Main Justice. I've also recently guested on The Bulwark. This is a theme that is just all of us keep on hitting, which is this is it's so easy to say that this is about politics. It's not. This is just about rule of law issues. The reason you're seeing people who have all sorts of political views, I don't even, I've never even talked to Mary, for instance, about like her politics. It's because it's
Right.
irrelevant. And it reminds me so much of what it's like to be at the Department of Justice. You never talk about it because it's just irrelevant. You know what? If it's a bad guy, you don't sit there and go like, you know what? It's a pedophile, but he's a Democrat, so it's okay. I mean, you would never do that, right? It's just
No.
like you didn't sit there and go like, oh, I started out doing it organized crime cases. Do you know what do I know about whether they voted Republican or Democrat? It's like it would just be the last possible thing you would think of. The point being is that the 11th Circuit, like so many of the judges and even some justices we're seeing, are just focused on the rule of law. And as you pointed out, Adam, there's so much in this decision that it just ignores facts and misstates facts.
Right.
And so it's really hard for me to think that this isn't strike three and you're out.
Mm. Right. Well, we'll see what happens with that. And I think that to your excellent point about the fact that this is these were proceedings that had no adversarial parties. That this was the Trump DOJ, Trump, Walt Nauta, and Carlos de Oliveira. They were all on the same page. Any party that wanted to be an adversarial party was shut out the door. When you were saying that, it reminded me of a situation in snowy New York City involving a federal judge, as you said, appointing an amicus in the case of former Mayor Eric Adams. There weren't adversarial parties because Trump had taken over the Department of Justice, fired those prosecutors, and the judge wanted to hear from someone who'd present the other side and did
Perfect.
just that.
Perfect. That is a perfect, more recent example of that. Exactly. And that is what you do in those situations where the government and the defense are agreeing, but there may be another position. The court, as a matter of fairness, says, yes, I'm going to appoint somebody. And the idea that you wouldn't do that with the Knight Institute, where it's so reputable. I mean,
Right.
I could understand if you thought that the person who was intervening was not sort of the person who should be carrying the or rowing the what is it rowing the oar, pulling the weight, whatever
Right.
well, whatever that expression is. But the Knight Institute is, if you're looking for somebody to present sort of the First Amendment issue on what to do, that is sort of the preeminent group to be setting out that position. And that's not going to be lost on anyone. That's who we're dealing with. So,
And so I think that's a really good point to end on. We have about 2,250 people watching right now. It's ticking upwards. If you are joining a little late, is there something else you wanted to say? I think you were about to introduce.
well, I just saw that somebody was asking, can the chief judge do something, whether it's the chief judge in a district court or the chief judge in a circuit court? And the answer is no. They have limited jurisdiction. The chief judge wouldn't be able to do something in this regard. But as I said, the appellate court has really total control over what happens next. And they have various ways, as I said, some more intricate and slower than others, to deal with this issue. But they can deal with it. Maybe one other thing, which is, there were many people. I've had this conversation with our friend and colleague Joyce Vance, who's very, very much. She was the Alabama U.S. attorney, so she's very, very familiar with the 11th Circuit. There was a lot of discussion when Jack Smith was the special counsel about whether or not the Jack Smith should have tried to recuse Judge Cannon from the case. And this is like, hindsight is 2020. And of course, some of us were saying this at the time of whether they would or would not. And there was a lot of thinking that the 11th Circuit might have been very receptive, given what she was doing and given her track record before them, that she was not either didn't have the right experience to do the case. If you remember, there was a lot of discussion with the chief judge at the time about whether she should stay on the case. He
Right.
couldn't just remove her, but there was some discussion about that. I think it was she couldn't just remove her because it was a woman who was the chief judge.
Correct. Yeah.
But one of the things that Carol Lenig and Aaron Davis have reported in their book Injustice is that Jack Smith did seek authorization from the department to make a motion to recuse her, and did want to take it to the 11th Circuit. And because Jack Smith, like Mueller, is a special counsel within the Department of Justice, he has to obey Department of Justice rules. And the then Solicitor General, a wonderful lawyer named Elizabeth Preliger, disagreed and did not give the necessary approval. You can't just do it on your own. You have to have the Solicitor General's approval. And so you really can't fault Jack Smith on that one. You may think it was, the right call for Elizabeth Prelogar to do that. I'm not weighing in on that for the moment. It's just that, in fact, it's reported by Carol and Aaron that he did seek that authorization.
Mm,
But we're now in the position where the 11th Circuit, one way or the other, is going to have before it the issue of Volume 2 and whether it sees the light of day. And the one thing I can say is at some point we will see it.
mm,
But this is one where, in my view, um, that day should have come already. And so this is Adam, you're a journalist, and so
mhm.
you understand this more than anyone, which is if there is a public right to know, any day that's not being vindicated is a day where there's damage
Right.
to the First Amendment.
Right. And I think that your expression that this will see the light of day is the most confident expression of that sentiment that I have heard yet. And so that's the very hopeful note to end on. I'll say one more thing in my journalistic experience in this case. Judge Cannon sits in a federal court in Fort Pierce, Florida, which is very, rather small, sleepy, technically a city, but a rather small town. And had this gone to trial there, every journalist who covered that court sat in a rather relative matchbox of a courtroom that you would expect for a trial of this magnitude. It just seemed crazy to so many journalists, and myself included, that this case, amount of just to think of, do they have hotel capacity? Do they have Wi Fi capacity? Just logistical considerations. And there was never any kind of serious thought of, okay, maybe we just send this back to Miami, which is more capable of logistically pulling off the trial of the century because Judge Cannon sat here. This is how she chose to adjudicate this case.
Well, you don't have to worry about the size of the courtroom if you're never going to have a trial.
Right. And that's where we stand today. And here we stand with two people in very similar shades of gray sweaters, expressing hope and confidence that truth will eventually see the light of day. Always a pleasure, Andrew.
Take care.
And folks who are joining, maybe you joined late, if you want to see the full conversation, we're up to 37 minutes now. Take a moment to subscribe to both of our Substack publications. I'm All Rise News and Andrew Behind the Headlines, correct?
Correct. Thanks. Thanks for the plug.
You got it. You've got it. Have a great day.
Okay. Take care.
Bye bye.